Welcome back to Radio Entrepreneurs. I'm Jonathan Freedman. Our next guest up, Tom McNulty of Lando Anastasi. Welcome to Radio Entrepreneurs.
No, thank you for having me once again.
I always feel like I got to welcome you, Tom. You know, we see one another on a regular basis. It's always great to have you on the show.
Yeah, I enjoy this. It's a good time.
So you want to talk about something that I think is probably all too common today, and something that many people are probably doing unwittingly. Let's just assume that's the case. You want to talk about copyright infringement and utilizing images and other types of things that people collect off the internet.
Yeah, there's been sort of an explosion of cases relating to this. Typical scenario is somebody's setting up a website. They want to, decorate the background with images related to whatever it is they're, whatever goods or services they're selling. Sometimes you see it come up in the context of, people sharing, Instagram pictures or Facebook posts, things like that. So it's kind of, websites and social media is sort of the area for it. And they will go online and find an image that looks like, it might be something nice in the background or something nice to illustrate something, and just, copy it and paste it onto their website or into their social media without really thinking about any of the intellectual property rights that go with it. Sometimes it's the individual businessmen themselves. Sometimes they've hired a web designer or a social media, company to do this for them.
And it's not the case where that image needs to have any sort of watermark that indicates that it's proprietary of any sort. This is just any image that you find.
Yeah, absolutely. There's somewhat of a misconception that if there's not the circle C or some kind of watermark or some kind of identifying information, that it's free for the taking, and that's just not the case. Under U.S. Copyright law, the copyright vests in the photographer or whoever took the image as soon as it's fixed in a tangible medium. There's no requirement anymore that it be marked with a copyright signal or anything like that. So basically everything you see on the internet, somebody has copyright rights in. Whether they will choose to enforce it or not is a different question, but somebody's got rights to everything that's on the internet.
And where are you seeing the explosion in cases? Are they cases wherein, because again, it would seem to me that obviously if a company has a legal department that is protecting their properties and/or somebody that's looking out for that, it would make sense. But it would seem to me that most photographers that are putting their images out there are probably don't have the resources and the means to track who's copying and pasting, especially if it's not protected in some sort of way.
Well, I mean, that's sort of the interesting thing. I think there's two things that are driving this. The first is there's been considerable improvement in image recognition software. And there's software now that basically you can plug in your pictures and it'll comb the internet and look for infringements, look for copies. So the technology behind that has dramatically improved over the last 4 or 5 years. And then the second factor that seems to be driving it, at least based on what I have seen, is there's a number of litigation firms that have opened up basically solely to pursue this. So they have the software, they hire a bunch of photographers, upload their images, and comb the internet looking for infringements. Oftentimes they'll file suit without the photographer actually being aware that an infringement was found, which is sort of questionable from a legal ethics standpoint.
Is that the equivalent of would that be the equivalent of ambulance chasing?
It sort of is. I mean, I do want to say up front that I'm going to be critical of some of these practices, but I do want to say up front that if you are taking a picture off the internet and putting it on your website, that is copyright infringement. You shouldn't be doing it. So whether you like these people coming after you or not and think that they're doing ethically or not, it is something that you've kind of put yourself in the position to have to deal with.
And I want to be clear, it's not just publishing the image, it's utilizing the image in any fashion or not. So if I was to use it as a screensaver, for my own usage, as opposed to broadcasting it or publishing it in any way. Is that a gray area?
I mean, yeah, strictly speaking, you can't download it and use it as your screensaver, but I don't think they're going to be able to find that. It's more when you put it on the internet yourself. So like I say, a lot of times it's you see a lot of like hotels and travel agencies that will take pictures of locations nearby as part of their pitch to use their services. So that's sort of the scenario where you're actually trying to not necessarily profit off the photo itself. You're not selling copies of the photograph or something like that, but it's really more geared towards like a sales pitch. But you also see it sometimes. I had a client that he was building a new website and he just wanted some general kind of background pictures of the technology he was working in, not necessarily his products, not necessarily anything he was pitching, just sort of the sort of basic stuff to be the background for his website. And he had somebody come after him because they took a picture that was on the internet and copyrighted and used that as their background. The thing that makes this sort of scary, if you're somebody that gets a notice or gets sued on this, is copyright law, unlike most litigation matters in the United States, has a fee shifting provision where the prevailing party can be awarded their costs and their reasonable attorney's fees. So even if you think that the infringement is sort of de minimis and there's not a lot of damages to be had, there's this threat of attorney's fees hanging over your head.
Which can escalate rapidly.
Yes, they can. And the other part of it is there's actually a statutory damages provision where if you can't quantify specifically what your damages are, or if it frankly just seems like it's going to work out better under the statutory provision, you can get statutory damages anywhere in the range of $750 to $30,000 per infringement. If the court determines that you willfully infringed, that you sort of knew what you were doing and went ahead and did it anyways, they can increase the amounts up to $150,000 per infringement.
Wow.
So a lot of times, particularly from some of the perhaps less scrupulous copyright attorneys out there, you'll find out that somebody thinks you've used their image by receiving a lawsuit and a demand for $30,000. Which it's a big deal for people, particularly for a lot of these images you can get on like Getty Images or any of the stock image companies.
That's what I was going to say. Right. It seems to me that the cost of the image at a couple of $100 is a far better investment than running that risk.
Yeah. So I know there's people get these complaints and they feel a lot of pressure to settle and to offer big chunks of money. So that's one of the things I kind of really wanted to go into here is, despite the fact that there's attorney's fees available and statutory damages available, don't necessarily assume that there's going to be a big payday for the other side when they come after you. There are some limitations on how much can be awarded and when courts will award that I think it's important to bear in mind. Statutory damages, were never intended to be kind of a windfall for the copyright holder. They are supposed to have some reasonable tie to the measure of damages that the photographer would have suffered. So like I say, if there's images that are available on a stock image site for a couple of $100, the courts will probably take into account the need for deterrence and they'll probably up it from there, but they're not going to up it to 30,000. It might be in the, high hundreds to $1,000 range for something like that, assuming you're not, a willful or repeat infringer or something like that. And the same thing with attorney's fees. While they can award reasonable attorney's fees, the sort of reasonable part, it has to be somewhat tied to the amount of damages that could reasonably be expected. So if somebody claims that they've rung up $50,000 drafting a complaint for what might be a $500 award, they're not going to get $50,000 from a court.
So it sounds to me like the message here is that there's good news in that if you are accused of or guilty of, let's just say accused of copyright infringement, that perhaps the penalties aren't as severe as some attorneys may make it out to be.
Yeah, they're likely to be less.
The flip side is you can mitigate all of that by going out and spending a couple $100 and just paying for the images that you're going to utilize and publish.
Oh yeah, absolutely. There is one other thing that sort of comes into play with all this. There's a separate statute that makes it a civil tort to remove copyright management information. So for example, if somebody's got a watermark or a copyright insignia or identification of the photographer or gutter credit, that kind of thing, if you remove that and then republish the photograph without it, that is a separate violation, That also comes with the possibility for actual or statutory damages. In this case, statutory damages run from 2,500 to 25,000 per active removal. That can be tripled if you're a repeat offender. Repeat offender is kind of defined as having been found to have violated the statute within 3 years of previously having been found to violate the statute.
It would seem to me it would be difficult to prove that that was not willful if you actively remove a watermark.
Well, there's some interesting examples of when it's not willful. There was a case of a company that was posting pictures of houses to the MLS listings, for real estate sales. And the way it worked was the picture was reduced to a thumbnail and put on the MLS listing as a thumbnail. And the sort of technical process of reducing it to a thumbnail, which was, automated, it wasn't like somebody was making this decision, just so happened to crop out the gutter credit. And that was a case where that was found not to be willful. So, if you do get accused of it, and again, don't do this. I'm not advocating anybody do this because they think they're going to get off. But if you do get accused of something like that, there may be some ways around it, or some ways, some defenses, I shouldn't say around it, but some defenses that can work in your favor. So these are all sort of things to bear in mind if somebody comes at you with something like this. There's also the possibility on the copyright side of a fair use defense. There are instances where copyright law permits you to go ahead and actually copy somebody's work without license and without payment. The fair use kind of things are, it's typically news reporting, scholarship, teaching, that sort of thing.
Is that what people historically would thought of as public domain? Once it's out there and it's sort of access, or is that's different? That's things like happy birthday.
Yeah. Well, happy birthday was kind of a contested issue for quite a while. Public domain is when things, when the copyright has lapsed. Copyright law, at least theoretically, doesn't go on forever, although they keep extending it every time the Disney stuff comes close to going off copyright. Seems to be the driving force. But like 1800s classical music compositions, the music itself is not subject to copyright at this point. If you've got a recent recording, say, of the Boston Symphony Orchestra doing it, the recording is going to be subject to copyright, but the underlying piece of music is not. Fair use applies to stuff that is still subject to copyright. So that's the kind of, there's a recent case that involves somebody publishing, it was a Cardi B Instagram post, I think it was, that the underlying photograph of Cardi B herself was taken by a photographer who claimed copyright protection in it. And somebody had published the Cardi B post as part of a news story about what Cardi B was doing. And the fact that she published the post and the contents of the post were kind of part of the newsworthy angle of it. And that was found to be a fair use.
Interesting. So as always, Tom, taking some stuff that seems to the layperson to be pretty straightforward and putting some context around it, always very valuable for our listeners, I think. And if people want to talk to you about whether it's copyright infringement, whether they have an idea, whether they've been contacted by somebody who's indicated that they've violated their copyrights, what's the best way for people to reach out to you? And can you assist in all those matters?
I certainly would be willing to look at any of those matters. Yes. The best way to reach out to me, you can find me on our firm website. I'm with Lando Anastasi. It's www.lalaw.com. And you can get me at my phone number, 617-395-7040.
Excellent. Tom McNulty of Lando Anastasi. Always great to have you on. Always great to hear your insights into everyday practices that people might take for granted and should be watchful and wary of. So always great to have you on Radio Entrepreneurs.
Thank you. It's been a pleasure.
And we'll be right back with another segment on Radio Entrepreneurs.